Hey Jeff, I would love to learn more about how to file a wrongful death claim.
Sure, thank you, Krista. This is a call that I get quite frequently. In Florida, if you have a loved one who dies as a result of somebody else's negligence, whether it's a slip and fall or an automobile accident or truck accident or motorcycle accident or medical malpractice, whenever there is a death and it's caused by somebody's negligence, then you have a wrongful death claim. Now, the way it works is the only way to file a wrongful death claim is through a personal representative. So if your spouse dies, you can't simply just file a lawsuit on her behalf. You have to actually be appointed the personal representative of her estate in probate court. And then once that is established, once the personal representative is established, then a lawsuit can be filed. And Florida's wrongful death statute is Chapter 768. And it basically provides that the personal representative will file the lawsuit to include um, compensation for the survivors of the estate. So survivors can include a surviving spouse, um, children, or if a child dies, their parents can be survivors who are allowed to recover. And there are some nuances for medical malpractice. It's handled a little bit differently if you have a malpractice case. But generally, parents and children and spouses are typically the survivors, and you can sometimes run into difficulty. Let's take an example. Say a 20-year-old um, child dies, and his parents, he's not married, and his parents want to bring a claim for wrongful death, but the parents are divorced and they don't get along and they don't speak. So you potentially have a conflict there as to which parent is going to be the personal representative. Or if they just simply can't agree, sometimes a third party, a neutral party, will be appointed as the personal representative to pursue a claim. And then sometimes you even get into arguments. Let's say you make a recovery and you get $1 million in the wrongful death case. Sometimes there's an argument between the survivors as to who's entitled to what. So sometimes they'll argue, well, I saw him more and I spent more time with him, and you lived in another state and you rarely saw him and you rarely talked to him, so you're not as entitled to as much as I am. As you can see, these things can get very complicated. So it is absolutely critical that you hire an attorney who's experienced in wrongful death claims as soon as possible after you've grieved and you're recovering. Get a lawyer involved. Let them set up the personal representative and the estate so that a lawsuit can be filed, and let them help walk you through what all the issues might be when the survivors can't agree on the appropriate payout.
Okay, awesome. What will the second question be?
The second one is, can I file a lawsuit if I um, was partially at fault?
Okay. Hey Jeff, can I file a lawsuit if I am partially at fault?
Yes, the answer to that is yes, most definitely. But there are some special rules and laws in Florida that you need to be aware of. Many times there's an accident and somebody just blows a red light or runs through a stop sign and hits you, and there's absolutely nothing you could have done. And it's clearly 100% the other driver's fault. Or, if you're at a stoplight and they rear end you, there's no issue. It's clearly the other person's fault. But in many accidents, and especially in slip and falls, the defendants will argue that, well, we might have had some fault, but you were at fault too. You as the plaintiff, as the person making the claim, you should have paid attention where you were going. You should have seen this other car coming. You should have avoided it. So it's not all our fault. You are responsible as well. And in Florida, historically, over the last 20, 30 years or so, um, you could sue and make a recovery if you were 90% at fault, if you were 80% at fault, if you were 50% at fault. Um, that was not a bar to recovery. So let's say you were seriously injured and you had a recovery of $1 million, and a jury found that you were 90% at fault and the defendant was only 10% at fault. Well, your $1 million recovery would be knocked down to $100,000 because the defendant was only 10% at fault, which is $100,000 of $1 million. And so that is the way that it typically works. So for any accidents that happened in the past, that's the way the law would work. In March of 2023, a new law was enacted in Florida. And so for any accidents that happen after March of 2023, that's no longer the case. If you are found to be more than 50% at fault, you get nothing. And that's a very harsh law. I'm not sure I understand what the reason for that is. It doesn't seem to make a whole lot of sense to me that somebody could be 49% responsible for causing your injuries, but because you were 51% negligent, you get nothing. I don't understand that. I think the law as it was before March of 2023 was fine, but that's what we're dealing with now. So for any accidents after March of 23, that is the new law. There's also a law that has been around for many years that says that if you are intoxicated and you are found to be more than 50% at fault for an accident, you get nothing. So it is very important that you hire an attorney who is experienced and has the wherewithal and the knowledge and the ability to prove that you were less than 50% at fault for an accident, put most of the fault on the defendant so you can make a recovery for your injury. So I highly recommend in any type of accident, whether you were at fault or not, that you hire an experienced personal injury attorney as soon as possible.